Alright, I'll grant you a right to use my land.
Thank you.
So, this is an easement. But, do you really know what is an easement? Let me explain to you. According to Section 282 subsection 1 of the National Land Code, easement is defined as a right or privilege given to a registered proprietor of a piece of land to utilize another piece of land for the beneficial enjoyment of the former's land. And according to Section 282 subsection 3, the dominant land will be the land benefiting from the easement, while the serving land would be owned by the proprietor of whom the right has been granted. The right to enjoy another's land is a private dwelling based on the personal agreement with the mutual consent between two or more parties by the registration and execution of the easement. And this may be called a personal covenant between two different landowners where the rights are not imposed but acquired. The notion of registering the dwellings, which in this case includes easement, is parallel to the torrent system which can be seen from Section 206 of the National Land Code.
So according to Section 283 subsection 1, the rights granted can be divided into positive rights and negative rights. The positive rights refer to any right to do something on the serving land, and the negative rights prohibits the owner of the serving land from doing certain acts on his property. However, subject to subsection 2, the said rights do not include, first, any right to take anything from the serving land, second, any right to the exclusive possession of any part of the land. However, the placing and the maintenance in or upon the serving land, any installation or other works for the benefit of the dominant is permitted. In short, when the dominant landowner is granted an easement, he is granted the legal right to use the property, but the legal title to the land itself remains with the owner of the land.
Now, let's have a look at the characteristics of easement. There are 4 characteristics of easement that had been laid down in the case of LIA2005. Firstly, in this case, it was held that an easement may be granted as long there must be a dominant and a servient land. This characteristic has also been reflected in Section 282 subsection 3 of the National Land Code. Secondly, an easement must accommodate the dominant tenement. This characteristic has been acted in parallel to Section 282 subsection 1, where it clearly says that it shall be for the benefit of the dominant land. Thirdly, the dominant and the servient owners must be different persons. In other words, separate land titles. And lastly, the right over a land does not amount to a legal easement unless it is capable of forming the subject matter of grant. These characteristics has 3 sub-rules that have to be established. Firstly, whether the right conferred is too wide and vague. Second, whether it is inconsistent with the proprietorship and position of the alleged servient owners, and whether it is a mere right of recreation without utility or benefit. Mentioned earlier are all about the English standing or English position on easement. How about Malaysia then? In the case of Tam Kam Tiong, Justice Salah Abbas stressed that in establishing a claim of easement, such claim must possess all 4 requirements mentioned in the previous case, LIA2005 case. Thank you.
Next, nature and effect of easement. An easement can be created for a certain period of years or in perpetuity, so far as the grantor of the easement permits. This is as shown in Section 286 subsection 2 of the National Land Code. While subsection 3 provides that there will be implied ancillary rights that are reasonably necessary for the full and effective enjoyment of the easement. Furthermore, cost of the work forming the subject matter of easement may be subject to the agreement between the dominant and servient proprietors. It can be borne by both or either one of the parties as provided in Section 286 subsection 4. In Section 286 subsection 5, the parties may agree to make periodic payments to the servient proprietor as consideration of the grant in the agreement for the grant. This agreement of easement and payment will be binding on the proprietor and successors in title. The benefit of these easements can be enjoyed by any lessee, tenant, or chargee of the dominant land. They may take actions that are necessary for the enforcement of easement in their own name, as laid down by Section 287.
Hey, so how do you terminate an easement?
So, an easement can be terminated in three circumstances. The first circumstance is a release by a dominant proprietor. Under Section 289, subsection 1, an easement granted can be released at any time by the dominant owner. In simple terms, in the event that the dominant owner no longer wants the easement, he may release the servient owner. Any such release by the dominant proprietor then must be effected by instrument in Form 17C, and the easement will cease to exist on the date which the instrument is registered. Under Section 289, subsection 3 of the NLC then, a consent of any lessee, tenant, or chargee entitled to the benefit provided by the easement has to be obtained and is necessary and must be signified in Form 17C.
And the second method to terminate an easement is via the extinguishment by unity of title and possession. Section 290 of the National Land Code laid down three conditions for the easement to be extinguished by operation of law. All three conditions must be met before an extinguishment can take place. Firstly, the dominant and servient land are vested in the same proprietor. Secondly, no lessee, tenant or chargee is entitled to the benefit of the easement as per Section 287. And thirdly, the servient land is not subject to any lease or tenancy and not occupied by any chargee.
The third circumstance then to terminate an easement is the cancellation by registrar. According to Section 291 of the National Land Code, this provides for the power of the registrar to cancel any easement on four grounds. The first ground is that the easement has been extinguished by virtue of Section 290. The second ground then is that the term of easement has expired or in any event that has determined has taken place.
And the third ground is that the easement is abandoned. And finally, the easement is obsolete or impedes reasonable use of the servient land where there is a change of circumstances or facts of the case and that the cancellation will not injure anyone's benefit.
And that, my friends, is the gist of what is an easement. Now, let's dive into some of the examples.
This is Wendy the farmer. Oh wait, no! This is Wendy the farmer. Wendy owns this farm. She has been struggling to find a water source to rear her farm animals. One day, she realizes that there is a pond nearby, but she has to go through her neighbor's land in order to gain access to the pond. This is Gopal. He is the owner of the neighboring land, which is located between Wendy's farm and the pond. For many years, Wendy has long been accessing the pond through Gopal's land uninterrupted, with the absence of an express grant and registration between her and Gopal. On a fine day, as Wendy is getting water from the pond, Gopal happens to pass by and caught her.
Boy!
So, is easement established in this scenario?
The previous scenario is an attempted easement to obtain the positive right to access the pond via a neighboring land. Well, however, the easement is not established. It is important that we remember that easement can only be created via an express grant when it is registered and executed according to the procedures under Section 286 of the National Land Code. Now, let's dive in deeper to know about this grant. According to Section 284 sub 1 of the NLC, it is stated that easement cannot be granted by presumption of a grant from a long and uninterrupted user in Malaysia. What does it mean by long and uninterrupted user? This refers to prescriptive easement, which is not recognized in Malaysia. Prescriptive easement is obtained by an open and notorious use of servient land, which is adverse to the owner's rights. for a continuous and uninterrupted period of years, which is shown in the scenario by the farmer sneaking into the land for many years. Section 284 subsection 2 further explains that implied grant cannot create easement as well. However, this is subject to the exception in subsection 3, where an implied grant for ancillary rights is possible if necessary for the easement.
An example of the creation of easement could be seen in the 1985 case of E.W. Talala and Ng Yi Fong. The plaintiff sought an order to remove the defendant's septic tank that had encroached onto the plaintiff's land. On the other hand, the defendant claimed that the plaintiff had consented to the encroachment all along. Hence, this unreasonable delay in asserting for an order has stopped the plaintiff's claim. It was held that the consent or acquiescence of the plaintiffs is not sufficient to create an easement. An express grant of easement based on the provisions in the National Land Code is required.
In the 2013 Court of Appeal case of Cottage Home Syndrome Berhad and Wong Kau, the appellant and respondents owned two adjacent lands. The respondents in this case claimed a 12-foot wide road which gave them access over the appellant's land and used it for 2 decades with the previous owner's consent. The appellant, upon acquiring the land then, erected a 10-foot high fence and dug a trench which limited the access of the respondents to get to this land. In the Court of Appeal, Judge Abu Sama contends that under Section 284, easement is incapable of being acquired by long and uninterrupted use. It has to be granted by registration of Form 17A or Form 17P pursuant to Section 286 subsection 1 of the NLC. Therefore, in this case, for any form of easement to be granted, there should be a registration of land from the dominant landowner and the agreement in Form 17B of Section 286 subsection 1 of the NLC, and if not, easement is not established and there is no right acquired for the use of the other's land. Hence, the respondents claim that there was a right to use the land through the appellant's land was rejected. So, the reason why easement was not established in the case of Farmer Wendy and Gopal was because there was no registration of express grant which is in the form of 17A according to the procedures of the National Land Code. Now, let's look at what should have been for an easement to have been established.
So, Wendy the farmer and Gopal enter into an agreement so that Wendy can access the pond through his land. Upon the agreement, Wendy and Gopal goes to the land office to register the easement with an express grant.
This time, Farmer Wendy and Gopal proceeded to register with the express grant in Form 17A, and thus easement is now established as previously explained.
Here's a fun fact about registration. Section 206, subsection 3 of the National Land Code provides that the failure to register the express grant will not derogate its contractual operation. Section 206, subsection 3 is said to be an intervention of equity in land dealings. It is created on the foundation of equitable estoppels where the legal owner is estopped from denying the agreement even though it does not provide for any proprietary interest arising from the contract. In simple words, when an agreement is not registered, no easement is established under the National Land Code. But given that the contract is valid, the parties may claim for any remedies or damages under contract. However, the contract may only be enforced between the parties of that contract, whereas a registered easement under the National Land Code is good against the world.
And that is all from us. Thank you and bye-bye!